WCTV, connecting our community.
Why don't we call the meeting to order? It's 7 now. This is the Town of Wilmington Board of Appeals, December 22nd, 2021. It's via Zoom at 7 p.m. Pursuant to Governor Baker's COVID-19 orders suspending certain provisions of the open meeting law under General Law 30A, Section 18, imposing strict limits on the number of people that may gather. Members of the public who wish to watch and listen to the meeting may do so in the following manner: WCTV Channel 9, Comcast Xfinity Channel 37, Verizon Fios, and live stream at WCTV.org. This meeting of the Wilmington Board of Appeals is being conducted via remote participation. Therefore, no in-person attendance of members of the public will be permitted, but every effort will be made to ensure the public can adequately access the proceedings in real time via technological means. Members of the public who would like to listen to the meeting while in progress may also do so via telephone by dialing 1-646-558-8656 and enter meeting ID 893-3518-3983, then press pound, and then press pound again at the next voice prompt. Members of the public attending this meeting virtually will be allowed to make comments if they wish to do so during the portion of the meeting designated for public comment by following the steps previously noted, then press *9 on their telephone keypad. This will notify the meeting host that the caller wishes to speak. All callers using this feature will be placed in queue in the order in which they entered the prompt. In the event that despite our best efforts, we are not able to provide for real-time access, we will post a record of this meeting on the town's website as soon as we are able. Okay, I'm going to take things a little bit out of order. I have two administrative matters. We had case 2121, which was a request for a special permit under 6.1.6.4 to extend a non-conforming. I'm being advised that the applicant wishes to withdraw that without prejudice. Do I have a motion to that effect?
So moved.
We have a second.
Second.
We have a second by Mr. Siracusa. We'll have to do this by roll call. Ms. Santini?
Aye.
Mr. Barletta?
Yes.
Mr. Siracusa?
Aye.
And then myself, aye. Just for the record too, member Ray Lepore is not joining us tonight. He has recused himself from the hearing of case 2021, I believe. Yes. Okay, so that is withdrawn without prejudice, unanimously, 4-0. Then we also have, case 1818. They wanted to extend the special permit that we granted for them. I guess it expires on this, February 19th, 2022, and they want to extend it for 1 year to February 19th, 2023. It's 11 Commonwealth Avenue, the reason being supply chain problems and material problems. So do we have a motion to that effect?
Can I ask a question, Chairman? Is that reasonable time, a whole nother year? I mean, normally, or maybe it's a Kelly question. How long do they have for, generally speaking, anyways? Is it a year?
Yeah, and then they're looking to extend it for another year because I guess some of the materials they need to perform the work that they were allowed under the special permit aren't available or late. It's a relatively routine request given the circumstances. I mean, I don't see any problem with it. We already granted it, but again, it needs a motion.
Okay.
I'll make the motion.
All right,
Second.
motion by Mr. Barletta, second by Ms. Santini. We'll go through the roll call. Ms. Santini?
Aye.
Mr. Barletta?
Yes.
Mr. Siracusa?
Aye.
And then myself, aye as well. So that special permit has been continued. The expiration date has been continued to February 19th, 2023 for 11 Commonwealth Avenue. We also have the review of minutes of September 8th, October 13th, and December 15th, which we're putting over because Mr. Lepore, who was present at those meetings, is not here. So we're going to defer those to the next meeting, which is when, Kelly?
Now it'll be February. January, we have no new cases. So wait, February, I believe it's February 9th.
Okay, well, we'll confirm that, but those minutes will be reviewed and voted on the 9th, or on a regularly scheduled meeting in February.
It is
Okay.
February 9th, yep.
Okay, so the last thing on the docket is case 2021, map 41, parcel 111. This is a continued matter from our previous meeting, 615 Main Street. They are wishing to appeal the site plan review decision pursuant to section 6.5.5. The applicant is Stanley Stedman, and by CJ Alphin and Mark Bobrowski Esquire. Now, just so to let everybody know, I did confirm with town council that since we do have a member who's excused or recused himself, this is going to require a 4-0 vote. Just wanted to put that out there to everybody. Okay, Mr. Attorney Bobrowski, you have the floor.
Thank you, Mr. Chairman. Pleasure to see you again, members. Nice to see you as well. I want to thank you first for agreeing to accommodate us this evening. I had a bit of an accident a week ago, and I can just advise everybody to keep your eye on that last step going down the stairs. If you miss it, you're in surgery 3-4 days later. So that's where I am right now.
Who can we sue?
Me for being an idiot. That's pretty much it.
Do you have insurance? I'll bring it.
Multitasking is not my forte.
Okay.
So
well, I hope you're better. So go ahead.
You know, I had my pre-op meeting with the doctor this morning, and I'll be dancing the jig by January 10th. He tells me so.
Good for you.
This is unusual. I don't think I've seen a site plan appeal of the planning board to the Board of Appeals before. When I write the zoning in a city or town, I say that appeal should go directly to court, but you don't have that. So we find ourselves here reviewing one single condition in the planning board decision, which is that Mr. Stedman, who has joined me here this evening, will have a 20-foot opening ungated on the property line that he shares at 442 Main with the adjacent property owned by Cook Skating. And if Kelly, you can share your screen, I'll put up a couple of things for us to look at.
I actually can't, but I think Andrew. Can Andrew do that? Or is he?
He's thinking
I
about it.
don't have any material.
No, I have it here.
Okay.
Can you all see that?
Yes.
There we go.
Okay, I'm going to leave this up just as a picture of record that will help us understand the issue. Mr. Stedman's property is here. You can see the back of the building where I'm moving the cursor. And this is the lot behind 442 Main. This adjacent lot is behind Cook Skating. And I believe there's one other intervening business before you get to another side street on the other side of this building. And the Cook's also has frontage on Main Street here as well. Mr. Stedman tells me that some time ago, he began to notice that there was a considerable amount of cut-through traffic coming off of, I think that's 62. And in order to avoid the light at this corner over here where I'm moving the cursor, people would come through his lot, go through the Cook's lot, around the Cook's building, and back out onto 38 South, where they would then head for Woburn. And I can tell you firsthand, when I was here visiting the site the other day, I was at the light when a fire truck came in behind me and everybody else, and I had to get out of the way. So I pulled across the street, turned around, came back, and actually came in this side. You'll see that Mr. Stedman has put Jersey barriers up here with a fence. I don't think that the thing, it doesn't exceed 6 feet in height because I had my chin on it. And this is a crinkle here in which there is currently a 12-foot opening with a gate and some chain and some padlocks. That exists today. When I was here a week or so ago, I came in from this direction. There was an engineer in the parking lot making sure that the barriers were in the correct location. We chatted a bit. He was working for Mr. Stedman, as was I. And I kind of walked the land at that point. So again, cut through traffic coming through. Mr. Stedman has to maintain the integrity of these 8 parking spaces, 1, 2, 3, 4, 5, 6, 7, and 8. He requires those parking spaces for his site plan approval, and anything that would interfere with that would basically mean he would have to go back and get an amendment. So he put the barriers up for 2 reasons. One was that people were cutting through. At the time, he was the landlord for a martial arts studio. The martial arts studio complained that people were whizzing through the parking lot, and he worried for the safety of his customers. The second reason he put the barricade up was because some of the Cooks people coming to do business with the Cooks were parking in these spaces and then going across the lot and doing business and then coming back, taking up spaces again for the martial arts studio. The martial arts guy basically put him on notice that it wasn't a safe condition. And in order to reestablish safety on the site, Mr. Stedman put up these barricades. So long story short, once he did that, he got a notice from the fire department. I'm going to switch screens here for a second. Once he did that, he got a letter from the fire department, if you will, that he was out of kilter with what the fire department thought that he should be doing. Where's the history? Where did it go? I'm having, okay, can you see that now?
Yes.
Okay, this is Mr. Stedman's writing to the, probably to file more than anything else, or to the new tenant, I should say. And what he says is that the tenant, Ironclad Martial Arts, complained, so he notifies Cook that he and his customers are not allowed to go across his parking lot. He installs the barriers, if you can see that. After the barriers were up, there was a little trouble with some of them being removed. But most importantly, a few days after, he filed a police report because the barriers had been tampered with. A few days after the police report was filed, the chief notified me that the cement barriers may be in violation of an easement through the property, and the easement would, in the chief's opinion, benefited the town. Mr. Stedman asked the fire chief to forward a copy of the easement, and a couple of days later, the fire chief notified me that his statement was in error. The town does not have an easement on the property. So at that point in time, Mr. Stedman discussed with the chief volunteering to install a fire lane access at the location, roughly where the gate I pointed out earlier is located. And this is all in the fall of 2020. And they discussed a 10-foot, an 11-foot, and ultimately what you see in this picture that was installed is a 12-foot easement on the property. Not an easement, a 12-foot gate on the property. So again, this is the current situation out there. And this gate is 12 feet wide. Long story short, what happens next is that various people get involved in terms of trying to work out the arrangement here. And the I'm trying to share the old screen again here. Sorry for the trouble. So eventually what happens is that Mr. Stedman comes in for site plan review, which is necessary at the planning board because he's changing uses. He has a martial arts studio that would be for-profit education, and he's swapping it out for the new tenant, which is a kitchen installation cabinet sales. So retail, let's call it retail. That requires site plan approval. In the site plan approval, as I said, there's only one condition that is objected to, and that condition is that this opening has to be 20 feet wide. Let me say a few things about the nature of that. First of all, a fire access lane is, of course, required when somebody on their own property needs to provide access to the fire department to get to the building. That's not necessary on Mr. Stedman's property. He has access, as I said, and frontage on Main Street, so the fire truck can park on Main Street and reach the building. If the fire truck needs to reach the back of Mr. Stedman's building, there's openings here in the parking lot. They can come around, they can turn the truck around in here. We have an engineer who verifies that that's possible, and the fire truck can easily reach the back of his building here. When we do large projects like a 40B or some big apartment building, it's routine that the chief will come to the hearing and say, you know, I need a fire access lane here. And of course, we give the chief whatever he wants, because if he needs an access lane to get to the building we're proposing to build, he has to have assurances that there will be a safe condition. But here, what he wants us to do is to give him a fire access lane to reach Cook's property. And Cook can reach its own property. Cook has frontage on Main Street, and they can park the truck in front of their building just as easily as we can. And if Cook has a fire in the back of the building, they can come into the lot from this location and they can fight the fire. There's nothing to stop a fire truck from coming into this section of the lot here. I parked over here beyond the building. I walked across this lot. As I said, I met the engineer here. We conversed for a little while and back out. So there's no absolute need whatsoever for Cook's or Mr. Stedman to have a fire access lane at this location. Imagine the circumstances that this is a fence. Right? I live here, you live here. I put up a beautiful fence, I give you the good side, and now the fire chief knocks on my door and says, I need an access through your fence, 20 feet wide. You're gonna have to tear down a segment of that fence and you're gonna have to let me come through. For what? I need to reach the other building. You need to reach the other building, go this way, go around the block and come into the back of the building. There's nothing in the state fire code that says that one owner of land is required to provide a fire access lane for the benefit of another owner of land who can already reach his building from both sides. That's essentially what this is about. There's absolutely no need for that. And I've verified that with a couple of fire protection code companies, one called Code Red, which I conversed with last week, and also with the State Fire Protection Department out in Stowe. There's a complex out there. They train fire personnel, and they also are active in code enforcement out there. And again, there's nothing in the code that would point to that. So long story short, here's what we'd like to do. We're not going to give an open 20-foot access lane from this property onto this property. That's just not called for under any regulation that we know of. What we will do is maintain this gate at 12 feet wide and provide a padlock on the gate with a key to the fire department so that they can go through there if there's ever a need for them to do so. I can't imagine what that circumstance would be, but if they want to have the benefit of that, we're more than happy to give it to them. I believe that Mr. Stedman has already given the key to the fire department at that location, and it is 12 feet wide today. But we're holding fast to our position that this is not something that requires us to do anything more. And I'm, after, chasing my tail, talking to a number of different people in the fire protection business, I don't see anything that would provide a rationale that requires me to do that. So with that in mind, I'll ask if there's any questions.
Yeah, Mark, I have a question. You determined that there was no easement. Your client, I'm assuming, does not plan on granting the town one, correct? Obviously.
No, nobody has asked us to grant one, but what we simply found out was that there is not one. And that was based on the chief's research.
And I'm assuming that the reason, or perhaps one of the reasons that you're objecting to the 20-foot opening is because it would probably obliterate one of the parking spots.
At least one and possibly two.
How many parking spots, and I just don't know this off the top of my head, you might, how many parking spots does that business is required to have?
8.
So if you did what they wanted to, then you'd be out of code on with regard to the parking spots.
Right, and we'd have to come back and try to get some sort of a reduction in the number of required parking spaces to 6. And you've got a brand new business there that's just about ready to open. There, I think that when I drove out there, they've already put their signs up, and there's stuff in the windows that indicate that this is going to be a kitchen cabinet operation. They're on hold right now. They can't do anything until this issue gets resolved, and they're ready to be a productive, contributing member of the Wilmington community.
I mean, I personally, I don't think that your client should have to do anything, but if they have decided to do something, I think that they should do it in a way that doesn't harm them and put them out of conformity with some other part of our zoning bylaw.
Exactly.
So, I mean, I have no problem with your appeal. I think that it's pretty generous that your client allowed him to do anything at all because they don't have to. But if they're going to do it, then fine. Let me ask you another question. Is the opening that your client's willing to give to the town, is it wide enough to accommodate the vehicles that might use it?
A fire truck is 11 feet from mirror to mirror, Mr. Chairman, so I can't think that the biggest truck can probably get through there quite easily. They only asked for 11 feet. The lieutenant that Mr. Stedman was dealing with asked for an 11-foot security fire lane, and Mr. Stedman generously gave him a 12-foot. But I know
it was the planning board that is requiring the 20.
Yes, I'll call that up for you if you let me track it down here. The planning board in condition 10 of the site plan approval said, plans shall be revised to provide a 20-foot wide ungated opening in the concrete barriers to provide adequate fire access. We would like that condition to be nullified, and I think what we would be content to do would be to provide the town a license with a 12-foot opening that they may use.
I don't know why. I mean, again, I can't speak for the planning board, but I don't know why they would put a burden on your client to give the fire department, number one, something that they're really not entitled to, but something more than what they're even requesting. I don't understand that.
Yeah, the planning board got a letter from town engineer Paul Aluni on September 14th, 2021. They reviewed the site plan application, and he indicated, I'm sure he did this after consultation with the chief, we recommend the applicant provide a 20-foot wide access fire lane. And this just references the fact that the applicant placed concrete barriers. I think there's a fundamental misunderstanding about what a fire lane is and what it's designed to do under the state fire code. It's certainly not designed to give free unfettered access from one parcel to another parcel where both parcels can be served independently.
And if that's open, and if it's left to be open and unfettered, you're going to have all kind of beefs with the neighbor, with other people parking and using your spots.
I get the cut through traffic. I mean, the cut through traffic you know, we're in Eastern Massachusetts, anything goes. If you've got a route that you like, hey, for God's sakes, take it, right? So I can see how people would cut that corner in rush hour either direction to go south to Woburn.
Well,
Or coming back.
I'm also concerned though about there being disputes between the business neighbors with people who will use that egress or access to use it for overflow parking.
Well, that's already happened with regard to some Cook's customers parking in Mr. Stedman's spaces.
And it could be alleged that the cabinet people are doing it too.
They're not open yet.
No, but I mean, when they're open, it could be a back and forth, and
Well,
everybody could be using the spots.
Yeah, this will keep them on their property. Nobody's gonna hop that barrier, that's for sure.
I'll open it up to the other members of the board. I don't have a problem with, I do have a problem with the planning board's recommendation, but I'll open it up to the other members.
Okay, this is Tom. I have a few questions for you regarding this. So you had mentioned that the fire department had originally wanted it and they have rescinded it, the requirement for the 20-foot opening?
The fire department thought originally that they had an easement, Tom, and that turned out to be erroneous. So in the spirit of cooperation, Mr. Stedman met with representatives of the department. They asked for a 10. It was then increased to 11, and he voluntarily put that 12-foot opening in, hoping that that would solve the problem. And you know, just trying to be a supportive citizen here and help the fire department in whatever way he can without hurting his tenant. Anything beyond the 12 feet is going to eliminate a parking space, and he's in trouble under site plan review.
But so right now, officially, the fire department has officially stated or noted that the opening there that's locked is acceptable to them. Is that accurate?
I believe that's the case because they only asked for 11 feet and he gave them 12. Now,
No, I'm not asking for what you believe. I'm asking for, is there something in writing that says that the fire department is okay with the locked gate in a 12-foot opening?
Maybe I should ask.
Is there anything in writing that says that?
Let me ask Mr. Stedman to unmute himself and to contribute here. Stan? I don't know if he knows.
Hey, how is that? Is that okay?
Yep, go ahead.
Okay, what Mark failed to mention is that my initial visit with the fire chief was we discussed that I would voluntarily put a 10-foot wide open fire lane gate and that was served with a registered letter. That first letter Mark showed was a registered letter. With that, the chief said he would meet me on site and we would explicitly show where the gate was and the 10 feet was. He sent a lieutenant. I don't have the lieutenant's name in front of me. Maybe Mark has it. A lieutenant met me on the site between 446, 442, and he says, Mr. Stedman, if you put the 10-foot gate here, that would meet the chief's requirements. I said to the lieutenant, I'm going to make it 12 feet, and under the fire chief's instructions, I will purchase a master key from D&D Lock and put the master key with a padlock with a chain, so that if an ambulance, a police car, or a fire truck goes into that property, they have the key. There were 2 registered letters directly return receipt sent to the fire department with both of those illustrations, meaning the first meeting with the fire chief telling me what needed to be done, I sent them a letter. Then the second item was that when the lieutenant met me, a letter was sent to him saying that we agreed and have complied more than what he was asking. Those were all done with registered letters. So if you say, do I have anything from the chief? No, but what I do have is 2 signed registered letters, and the fact that the chief did send the lieutenant at the site that's the best I can come to with the chief's cooperation in my plan to voluntarily put this fire lane gate in for the benefit of the community. It doesn't serve me at all. Thank you.
So, okay, so, and, you know, I would feel comfortable with something from the fire department and or the police department giving the okay for what you've done. I personally don't have a problem with what you've done, but, you know, I would rather focus my interest on what they say. They're the fire department, the police department. If they come back and say this meets all guidelines and it's good and it's right, I'm with it. But
When you say, if I could
you
interrupt you,
don't-
when you say that, are you saying to me that if what I'm saying to you is true, that the fire chief sent the lieutenant out, the lieutenant gave me explicit instructions, and I told him that I would hear it from the 10-foot to the 12-foot. If you're saying that the chief did send the lieutenant out and the lieutenant was completely in agreement with me, would you say that would meet your answer to your question?
No, I would say that would not meet it, and I would need something in writing.
Oh, I understand. Fine, thank you.
These are the letters that Mr. Stedman is referring to. He had an attorney at the time, Mr. Portnoy, who sent a couple of letters, one in September, the other one, I believe, in December, to the attention of the chief. Mr. Stedman's placed barriers on the property, met with Lieutenant David Woods,
Here you go.
who understood that he gave his approval for the installation of a locked fire lane barrier to allow emergency equipment to pass through. The lock's been put on. Here's copies of the portions of an email which Mr. Stedman sent to me. And then he followed that up with another certified letter. That's a certified letter. He followed it up with another one on November 1st. Again, enclosed his copy of an email, basically ending the matter.
Well, I mean, but there's nothing in writing again that the fire department had received it. I'm sure they did receive the request and the notions that it was okay, but nothing from the fire department indicating that they have granted this, other than words from a lieutenant and a parking lot.
Well, the fire department hasn't been asked to grant anything. We sought site
Well,
plan approvals on the planning board.
Well, originally you had said that they first wanted that opening. Is that
Yes.
true?
They wanted a
Okay, have they
20-foot
come
opening.
back and have they come back and have they said that they have rescinded that request?
I believe what Mr. Stedman is trying to convey to you, and this first letter backs that up, is that Mr. Stedman met on site with Lieutenant David Woods, who gave his approval for the installation of a locked emergency fire lane barrier. And that's 12 feet in width.
Okay, to me that's not good enough. I would want something in writing from the fire department.
Okay, well, we can chase
And,
down
and
Lieutenant.
if you get that, personally, I would be more than happy to approve this.
All right, we did request a meeting with the chief through Valerie, but it didn't pan out. So we can follow up with Lieutenant Woods. He probably will have a recollection of this, even though it's more than a year ago. But we'll see if we can get a letter from Mr. Woods saying that we did what we said we would do, and he gave his approval for that, and we're all good to go.
As long as they have stamped it, good to go.
Okay.
Can I ask a different question? The two buildings, the Cook's building and Mr. Stedman's building, were they always two separate properties, or were they ever combined?
If you're asking me, to the best of my knowledge, they was always separate. Right now, the only two properties that I would say that are part of mine, when you drive in from Church Street, I own the Rizzo's property, and then I own the property that goes up to 442 Main Street. But
Okay.
the other property, Coke's property, was never a portion. Matter of fact, there was never a joint piece of property, to my knowledge.
In on the site plan that's in the packet, there's a right-of-way easement, and that is my understanding of this is that's a right-of-way easement when the One Church Street property was built to gain access to, let's say, your landlocked property. That's the only way you could gain access to it. So you you have access around 1 Church Street into your property. So that was done during site plan approval for 1 Church Street, I'm assuming. Is that correct?
That's the best of my knowledge, yes, yes.
So that's a requirement on the 1 Church Street property. I just don't understand how, like, I have a big problem in Wilmington with the site plan review of all these landlocked properties in general. And I just don't think that the planning board can come back after the fact. And I agree everything with what Dan said earlier. I just don't agree that the site plan can come back after the fact and put these arbitrary requirements on bad conditions that were created by landlocking properties. This is no different than the fiasco at Starbucks with parking and the fiasco with the Sonic that was blocking the daycare in the back. You can't, I don't see any reason why we can't approve this tonight. I think the applicant's more than proven that he's gone out of his way. There's certified letters, asking them to contact Mr. Stedman if he has any problems. I don't see why we can't approve this tonight.
Well, Tony,
Tony,
I got another thing to add with that. I have a hard time believing, the fire department was apparently happy with an 11-foot opening. They
Yep.
were given 12.
Right.
At some point, the town engineer got involved and said, I think it should be 20. Now, where he came up with that, I don't know. But if I own that property and I didn't have and I didn't have to give anybody any right to enter that, I'd be a little ticked off that I'm going to give the town something I don't have to give them. And now the engineer and the planning board are requiring me to give them something that's going to cause me to be out of conformity with the parking lot spots needed under the zoning bylaw. So, I mean, now, do you really think that the fire department is now going to go back and say, even though the engineer and the planning board are requesting 20 feet, they're going to stick their necks out and say, oh no, we want something different? I think I have a feeling, Mark, you're not going to get any traction with that. That's just my gut.
Let me put it very simply. I'm more than happy to sit down with anybody, anytime and talk. I was hoping that we could just come tonight and present to you an agreement that the 12-foot gated locked opening would suffice for everybody concerned. That, as a mediator, that shouldn't have been a hard reach, but it was to get a meeting. So, and again, I wasn't the one making the phone call to get the meeting. Maybe there were other extenuating circumstances I didn't understand. But a 20-foot fire lane is customary and it's code, but it's not required for Mr. Stedman to give a fire lane to Cook any more than it's required for Cook to give a fire lane to Mr. Stedman. They can both reach their buildings adequately under the code. You have to be able to get the truck within 75 feet of the building. And in the front, it's on the street. In the back, it's easy.
The other part of this too is let's say Mr. Stedman puts a 20-foot gate in. How does the town now enforce that Cook's doesn't put a dumpster in front of the gate? I don't know how you enforce any of this, because it wasn't done in the original site plan review when Cook's was developed or whenever this. I just think that the planning board stuffs these buildings in the middle of these small lots and doesn't. I don't think I'm ready to vote on this right now and grant the relief. I don't see any reason why we should delay this.
Let me present what I think would be the perfect solution here. Rather than give you an easement, which requires a vote at town meeting to accept it and a lot of formality, what I would propose is that Mr. Stedman give you a license, which can be accepted by the Board of Selectmen. And the license would be written and it would be revocable. It would expire when, but only when, Mr. Stedman is no longer the owner of 442. And you take your chances with the new owner as far as what happens next.
But doesn't that have to be done? Hold on a second, Jackie. But if you do that, that license to use that gate only works if the other tenant or the other landlord on the other side of the building is
Yep.
cooperative with this, and what if he decides to put a dumpster in front of it?
Well,
I don't,
it's not on his property line. It's on our side of the property line. So you're right, Tony. He has the right to do whatever he's going to do. I would hope that he would be cooperative in the interest of having the fire department have access to his property if it catches on fire without having to come around the building the other way.
I think I would disagree with doing even suggesting that, because I think then that's opening up another can of worms and setting some kind of precedent that is going to just make it more muddy down the road. And I don't think you need to do that or should do that. I totally agree. I would be ready to vote to approve this tonight. I think the owner's done, Mrs. Stedman has done an excellent job on trying to be amenable, and I totally agree with, there's access on the other side of Cook's, there's access on coming from Church Street, and yeah, I would approve it.
Kelly, I had asked you to run this by Jonathan. Did he ever get back to you?
He did not, and I did, excuse me, I sent another email today asking if he had an opinion. His coworker, well, his another partner in the firm, stated that he was away. He didn't know about it, and he didn't want to, state his opinion.
That's fine.
I'm mindful.
What was the reason why we need
votes? So three doesn't do me any good.
What was the reason why you needed the legal opinion?
I just was interested in what Jonathan's opinion was. I'm ready to vote right now. I don't need Jonathan's opinion. I just was interested if he had an opinion on it. And I don't think we need it. I just think that it was something that might have been helpful. But I'm ready to vote. I have no problem with this.
So would the applicant be willing, if there was a motion in place to grant this with the condition that we would get the fire department approval, would that be acceptable to them?
I'm going to be candid with you, and I hope you understand what I'm saying. I think this has become more political than it is legal. I think that there's some bad feelings between the fire department and the incoming tenant. This is what I hear through the rumor mill. Not that I have my ear to the ground in Wilmington, but I don't know that I can go to the fire department and get David Woods to remember that in September of 2020, he agreed that this was okay with him. I don't even know if he still works there.
And you're going to have a fire lieutenant come out and say something that runs afoul of both the planning board and the town engineer.
No, I think the statements that are being made are political. What I'm trying to understand clearly and succinctly is does the opening where it stands with the 12-foot opening with the lock based on the site, is that conforming to fire safety? And I'm asking the fire department to say yes or no, because they originally said no. So the question I have is simple. Will the fire department look at the site and say, yep, this is a go. This meets the criteria, the standards of fire safety? That's simple. It has nothing to do with anything else but that for me. Why is that so difficult, and why is that political?
Because
yes or no to the fire department?
Because there is no requirement of a fire lane between properties which don't need fire lanes. There's no standard for that fire lane. A fire lane to reach the building today under the code is 20
That's
feet.
your opinion. I'm asking for the fire department to say that. Why is that so difficult to get?
I don't think it should be difficult to get. I'm just telling you that my experience so far has been that it's difficult to get. If it were
Well,
me,
I mean,
I'd give it.
I don't understand. I mean, you're a high-powered attorney. You have great respect. You mean to tell me that you can't send out a request for a reading on this and get get an opinion from the fire department? I don't understand why that's so difficult.
Well,
He's
I
got to
don't
come
either.
back with something, yes or no. And if he says no, he's got to give you an objective, a legal reason of why he's saying no. Why is that so hard to do?
We did request through Valerie's office a meeting with fire department representatives, and we were told that they weren't open to the idea.
So the fire department, Wilmington Fire Department, is not open to the idea, and we're going to accept it anyway.
They're not open to meeting, Tom. They asked for a meeting. They denied a meeting. I
Right.
don't understand.
There was nothing to do
Then,
with.
then go after them. You mean to tell me they denied the meeting, so what we do is we completely ignore what they're saying and move on. Is that what you're saying?
If I could add to that, prior to the planning board meeting, the town manager, as a courtesy, set up a meeting with Valerie, the fire chief, and the building inspector. At that point, we discussed the parking, and it was a courtesy meeting because I was trying to comply with the change of use as a courtesy. And at that point, I read a letter to the fire chief, and this meeting was recorded. I said to the fire chief that I explained to him that I sent them certified letters. I explained, I did this in front of everybody because they all, I mean, the town manager, Valerie, and the building department. And then I said to the chief, with it recorded, the fire chief, I did everything you asked for. You asked for 10 foot, I gave you 12 foot. I installed this gate completely on a voluntary basis. It has no benefit of me at all. To be honest with you, if the fence is an issue, maybe the best thing I can do is to remove the gate because it has no benefit to me at all. The only reason I jumped into this is Mark is saying to you, he couldn't get a meeting with the fire chief. What I would ask you to do is call the building inspector and ask him exactly what I told you about the meeting that was held and recorded. I said that in front of the manager, Valerie, the fire chief, and the building department, the tenant, my wife, and not a word was said to disagree that I did not comply. And I showed them all the registered letters. I showed them the police reports, everything. So the only reason I'm saying is Mark is trying to tell you, he tried to set up a meeting, and I'm telling you, I had a courtesy meeting and those people were there, and the building department will tell you that I'm in complete compliance, and the fire department said during the meeting, he acknowledged everything I said and it was recorded. So I hope that was right to say that, Mark. I was trying to support what you were saying where you couldn't get the meeting.
Well, you know, it might be that perhaps we could just give the member the recording. I mean, I've heard the recording. If you want to listen to the recording, that may be the answer. Why repeat the exercise if it's already been done once?
I don't think what I'm asking for is unreasonable. I really don't see why that is unreasonable.
Hold on, Tom, I got to disagree with you. You're asking, this man owns this property. There's nothing legally that requires him to do even what he's offered to do. So
why does the fire department? Why does the fire department say no? You're just
speaking now. Wait a minute, I'm
saying.
speaking. Tom, I'm speaking. I think it's unreasonable to ask a landowner to have to bow down to the town to get a letter that gives the town rights over his property that they don't already have. He's been generous enough to give them what he has given them. I think it's arbitrary, capricious, unreasonable. It's abusive to do that. And I'm telling you right now, I'm not requiring that to vote yes on this. But you do whatever you want to do. I think that's wholly unreasonable.
Well, that's your opinion.
Sure is. And you know what? And I'm going to also see if there's anybody from the town Andrew, is there anybody that wants to be heard on this that's in queue?
There is not.
All right, well, now I'm gonna open it up to the board. If somebody wants to make a motion, then go ahead and make a motion.
Mr. Chairman, may I ask a question?
Sure.
Do you have a fifth member that's just, I understand that there was one recusal, but do you have another
no, we
member
don't-
as an alternate?
We do not have alternate members. We used to operate with 3 members and 2 alternates, but it was kind of not workable because the alternates oftentimes would show up the meetings and not get to opine. So they just went to 5
I
members.
was thinking that if you had the Mullen rule and you had an alternate, they could watch the tape of this, they could familiarize themselves with the record, we could have a full 5-member board take the vote. But if that's not possible, I understand.
During this session that you had with the fire department, or they were in there, did anybody from the board listen in on that? Was anybody involved in that and listened to that at all for any reason?
I think Valerie was there, right, Stan?
You're saying when we had the courtesy meeting with the town manager? No,
Yeah,
no, just the building inspector, the fire chief, Valerie, and the town manager.
Just out of curiosity, even though we're appealing the planning board's condition, did the planning board comment on this ZBA case?
They did.
What did they
sent
say?
a memo. Basically, hold on. They state that planning board issued the attached site plan review decision, which is what they're disputing, and the board stands by that decision.
that's the only thing they gave?
Yep. Yes.
And it's the planning board's requirement, not the fire department's requirement, to be
It
clear.
is. Right, it's site plan.
There is a mechanism to appeal a fire department determination under the CMRs. I don't want to do that, but I'll explore that if I have to.
I'd like to, let's see where this goes. I'd like to make a motion to approve case 20-21 to appeal the site plan review decision pursuant to section 6.5.5.
Just by way of form, Jackie, you might want to state that you're making a motion to grant the petitioner relief from the condition, which is number 10, Mark?
10, exactly.
That's just, I think that might be.
So, and as stated, a relief from number 10, what,
Yeah, it is. It's condition 10.
condition
Yeah.
10
From the site.
of the site plan.
Do we have a second on that?
I'll second.
I'll second it for discussion.
That's fine. Tom can second. Yep.
Okay, so the question I have is the padlock that's hanging, where's the key with it? Where's the key?
It's a
believe-
master key that the fire department has. In other words, D&D lock has a particular lock. You go in there and say, I need the master key that fits the fire department. And I think it's a black key, but anyhow, the lock that's on there, an ambulance, from what I understand, an ambulance, a police car, or the fire department can go in there with a master key, undo the 3-foot chain and undo the padlock and swing the 2 gates open. There are 6-foot gates. And
Where is the key? Where's the key?
the fire department has the key. It's a master key. It's a fire department key, master key.
So you're saying that the key is in possession of the fire department?
From what yes, the chief told me to go to D&D lock. He will give me a lock that the fire department has a master key to. In other words, again, I want to repeat it. I believe an ambulance has a master key to it. The police department, that's the way it was explained to me from the chief. And the particular lock I have on it is a lock that's in compliant with the the fire chief's requirement. If he drives in there, puts his master key, opens the gate.
It's like a knock box on a public building. Fire department can come up, unlock the knock box, and they have access to the whole building. It's done.
I have a lockbox. I can put it in there also. I was only following the explicit instructions of the fire chief. I can put it, I have a lockbox there for the building. I can add another key to it. I can, certainly. D&D lock is right next door to me.
But the police and the fire department have that key marked for that particular lock. If they had to get into there, they have a key to unlock that padlock. Is that correct?
Just for the sanity of it, I'll back away from the ambulance and the police. It was referred to me that it was a master key for the public services. So let me just leave it with the conversation I had with the chief. His key is the fire chief has the master key to the lock.
Okay, so based on that, I think that's enough said. So based on that, I will accept it.
Possession is 9/10 of the law.
I will go for this. I will go for this.
So
Chairman, do you want me to state the whole number 10, the verbiage?
No, there's no need, Jackie, but I do need a second for the vote. It's only been seconded for discussion.
I'll second for the vote.
Okay, I'm gonna go through the roll call. Ms. Santini,
Yes.
Mr. Barletta,
Yes.
Mr. Siracusa,
Yes.
and then myself, yes. So it's unanimous 4-0. The site plan decision or the condition under number 10 of the site plan review has been appealed successfully and overturned. But I would state though that the 12-foot, the 12-foot opening and the key and everything attendant to it needs to be followed through on to conclusion, Attorney Borowski, whatever that means.
Perhaps in writing this up, Mr. Chairman, you could just substitute a 12-foot wide gated opening with master key to be provided to town safety officials.
Or in the
That sounds
lockbox.
great.
Can you do that, Kelly? Can you add that into the decision?
Just did, yes.
Okay.
I think that's all we need. Everything else is fine.
All right. Well, thank you all.
Thank you.
Kelly, is there anything further that we need to go through? I don't think so. I think we took care of it all, right?
I need
Correct.
to
We're
request
good.
the occupancy permit.
Pardon?
The planning board meeting was for me to get an occupancy permit. Does that mean I get an occupancy permit? I was denied an occupancy permit.
Yeah, I believe if the condition that you're objecting to is now been overturned, then I believe that should issue. I do not know the time frame for that.
Mark, you'll handle that?
I will, Stan. There's an appeal of the revised decision, and obviously we might have to wait a week or two, but I'll consult with Kelly and the building commissioner's office to get you a CO as soon as possible.
Thank you for your attendance of this evening.
Okay, everyone. I hope everyone has a Merry Christmas. Attorney Bobrowski, I hope you on the mend soon, and we'll see everybody on February 9th of 2022. Do we have a motion to adjourn?
Motion to adjourn.
Do we have a
Thank you all
second?
so much.
Thank you. Yep.
Good
We have
night.
a second. I'll go through it. Ms. Santini,
Yes.
Mr. Barletta,
Yes.
Mr. Siracusa,
Yes.
and then myself, yes. All right, Merry Christmas, everybody. See you in a few.
Merry
night.
Christmas.